Spotlight on trademarks. Today, we're going to discuss a new and important U.S. Supreme Court case that impacts trademark law, Jack Daniels versus VIP Products, handed down June 8, 2023, presented by Kelly Herzick. This lecture focuses a spotlight on trademarks. Jack Daniels versus VIP Products is a new case on trademark law and the defense of parity and the First Amendment, which is covered under what is called the Rogers test to trademark infringement claims and brand dissolution. It overturned the Ninth Circuit, which it held in favor of VIP Products. Justice Kagan delivered the opinion for the unanimous court 9-0. Justice Sotomayor and Justice Gorsuch each wrote a very short concurring opinion. Before we talk about the VIP case, let's do a quick refresher on the definition of a trademark. The Lanham Act of 1947, which is the core federal trademark statute, defines a trademark by its primary function, identifying a product source and distinguishing that source from others. A trademark is a distinctive mark, word, design, picture, or arrangement that a producer uses in conjunction with a product and tends to cause consumers to identify the product with that producer. The first part of the trademark definition, identifying the kind of things covered, is broad. It encompasses words, think Google, graphic designs like Nike swoosh, and so-called trade dress, which is the overall appearance of a product and its packaging. Think a Hershey's Kiss in its silver wrapper. Basically, a trademark is not a trademark unless it identifies a product source. This is a Nike, and distinguishes that source from others. It's not any other sneaker brand. In other words, a trademark tells the public who is responsible for a product in the marketplace. If a trademark is used in interstate commerce, to be protected, it must be registered with the U.S. Patent Office under the Lanham Act. If a trademark is properly registered, it has an R symbol from the previous slide, the holder of the mark can recover damages from an infringer who uses it to pass off goods as being those of the mark owner. The R symbol is the federal registration mark reserved for trademarks registered through the Patent Office. The symbol cannot be used until the Patent Office approves the registration mark. Now remember, a trademark holder can also get an injunction stopping the other party from using the mark. An unregistered trademark can still have common law rights. This is the TM symbol. TM stands for trademark. The TM symbol is usually used in connection with an unregistered mark to provide notice to potential infringers that common law rights in the mark are claimed. However, an unregistered mark is not protected under federal trademark law and cannot use the R symbol. That would violate the Lanham Act. Let's talk about trademark infringement and dilution, which are the two causes of action in the VIP case. The Lanham Act creates federal causes of action for trademark infringement and trademark dilution. So what is trademark infringement? In a normal infringement case, the question is whether the defendant's use of a mark is likely to cause confusion or to cause mistake or to deceive. In the typical case, the owner of a mark sues someone using a mark that closely resembles its own. The court must decide whether the defendant's use is likely to cause confusion or to cause mistake or to deceive. The keystone in that statutory standard is the likeliness of confusion. And the single type of confusion most commonly seen in trademark cases is confusion about the source of a product or service. Now, for trademark dilution in a typical case, the question is whether the defendant harmed the reputation of a famous trademark. A famous mark is one that is widely recognized by the public as designating the source of the mark's owner's goods. Dilution of such a mark can be caused by tarnishment. The statute describes tarnishment as an association arising from the similarity between two marks, one of them famous. This may harm the reputation of the famous mark and make the other trademark owner liable. However, there are exclusions. categories of activity not actionable as dilution. And one exclusion protects any non-commercial use of a mark. Another protects a fair use of a mark in connection with parodying, criticizing, commenting upon the famous mark's owner or its goods. The fair use exclusion, though, comes with a caveat. A defendant cannot get its benefit, even if engaging in parody, criticism, or commentary, when using the similar-looking mark as a designation of source for the defendant's own goods. As the U.S. Supreme Court explains it, the exclusion does not apply if the defendant uses the similar trademark as its own trademark. Next, we will be discussing the Rogers test. VIP Products claimed their dog toy was a parody and protected by the First Amendment and the Rogers test. The Rogers test comes from a case called Rogers versus Grimaldi from the Second Circuit in 1989. The Second Circuit created the Rogers test for titles of artistic works based on its view that such titles have an expressive element implicating First Amendment values and carry only a slight risk of confusing consumers about the source or content of the underlying work. The test is used to protect First Amendment rights where a trademark is used not to designate a work's source, but solely to perform some other expressive function. The test has been interpreted to have two prongs. One, determining whether the defendant's use is artistically relevant to the underlying work, and two, if so, whether the use is explicitly misleading as to the source or content of the work. Overall, the Rogers test aims to balance freedom of expression, which is protected under the First Amendment, with freedom from consumer confusion, protected under the Trademark Act. Basically, under the Rogers test, when trademarks are used in movies and songs, these have both been upheld under the Rogers test, but it has not insulated from ordinary trademark scrutiny the use of trademarks as trademarks, like VIP did. As the court noted, consumer confusion about source, trademark law's cardinal sin, is most likely to arise when someone uses another's trademark as a trademark. In such cases, Rogers has no proper application, according to the Supreme Court. In fact, Judge Gorsuch, in his concurring opinion, cautioned litigants on using the Rogers test as its overall viability has not been decided in the VIP Products case. That is for future cases. So let's talk about the specifics of Jack Daniels versus VIP Products, which just came out of the Supreme Court in 2023. If you look to the right, you can see the Jack Daniels bottle versus the Bad Spaniel. These pictures come straight from the Supreme Court opinion. I mashed them together for you so you can see the Jack Daniels bottle side by side with the Bad Spaniel's dog toy. You can kind of make your own decision as to whether there would be a confusion about the Bad Spaniel's toy versus the bottle. So here's the full citation of the Jack Daniels Properties case versus VIP Products. And here are the facts. Respondent VIP Products makes a squeaky, chewable dog toy designed to look like a bottle of Jack Daniels whiskey. The dog toy parodies much of the language on the original Jack Daniels label based on bad dog potty humor. On the toy, for example, the words Jack Daniels becomes Bad Spaniels, and the old No. 7 brand Tennessee Sour Mash whiskey turns into the old No. 2 on your Tennessee carpet. Jack Daniels Property, which owns trademarks in the distinctive Jack Daniels bottle and in many of the words and graphics on its label, did not appreciate the dog humor and demanded VIP pull the dog toy from the market. While Jack Daniels lost in the Ninth Circuit, they won at the Supreme Court level, and VIP Products lost. The Supreme Court looked at two issues, and they're fairly narrow. Should Jack Daniels have to satisfy the Rogers threshold test and the First Amendment before the case could proceed to the Lanham Act's likelihood of confusion inquiry for its trademark infringement claim? Does VIP Products' use of a Jack Daniels trademark fall under the non-commercial use exception as a parody and insulated from Jack Daniels' claim of trademark dilution by tarnishment for the linkage of its whiskey to, shall we say, less savory doggy substances. And here are the holdings of the court. When an alleged infringer uses a trademark as a designation of source for the infringer's own goods, which VIP did, the Rogers test does not apply. For trademark dilution, the non-commercial exclusion does not shield parody or other commentary when its use of a mark is similarly source identifying. The Supreme Court held only that the Rogers test is not appropriate when the accused infringer has used a trademark to designate the source of its own goods. In other words, has used a trademark as a trademark. That kind of use falls within the heartland of trademark law and does not receive special First Amendment protection. And with respect to the dilution claim, the court held that the use of a mark does not count as non-commercial just because it parodies or otherwise comments on another's products. Given the fair use provisions carve out statutorily, parody and criticism and commentary, humorous or otherwise, is exempt from liability only if not used to designate or identify a source. Now, on remand, when it goes back down to the trial court, the key issues will be whether the dog toy is likely to cause confusion about the source of the toy as being from Jack Daniels, or if the toy tarnishes Jack Daniels' famous brand. What I want you to remember about the VIP products case is that the opinion is narrow. The court left for another day a decision on whether the Rogers test is ever appropriate or how far the non-commercial use exclusion goes. On infringement, the court held only that Rogers does not apply when the challenged use of a trademark is as a trademark. In dilution cases, the non-commercial exclusion does not shield parody or other commentary when its use of a trademark is similarly source identifying. Both holdings turn on whether the use of a trademark is as a trademark. The Lanham Act makes that fact crucial in its effort to ensure that consumers can tell where goods come from. If you have any questions about trademark issues for the class or about this video, please do not hesitate to email me. This is the end of the presentation.